this installment, I'm going to cover some important things to consider when developing ideas for a protectable band name. As in the previous episode, because the same basic body of law applies to trademarks and service marks, I'm going to refer to them generally as trademarks or marks. I mentioned in the previous episode that marks can consist of words, numbers, designs, and even sounds and smells, as long as they are capable of distinguishing one provider's goods and services from those of others. But not all marks are capable of federal registration, and equally important, not all marks enjoy the same level of protection even if they are registrable. When considering band names, or any new mark for that matter, it's important to strive to select a mark that is protectable. In fact, the strength of a mark is one of the most important things to consider before adopting a particular mark. The more distinctive a mark is, the stronger it is, and more protectable it is. It's helpful to think of the strength of a mark by visualizing different categories of strength on a scale like this one. The weaker categories of marks start on the left-hand side, and as we move to the right, the categories become stronger. Generic marks, which are simply the names of applicable goods or services themselves, appear on the far left side. These are the absolute weakest marks and are not capable of federal registration. They also are afforded no or extremely little protection. For example, Apple for a brand of apples is a generic mark. But as we'll see in a minute, that same mark is a very strong protectable mark when it's used to identify other types of goods, specifically computers and electronic devices. An extreme example of a mark that would be considered generic for a band would simply be band or musical group. We'll leave for another day any discussion of how much or how little protection the classic rock group The Band might have enjoyed in its name. Next, descriptive marks are those that directly and immediately convey something about the characteristics or ingredients of the applicable goods or services. A descriptive mark is only protectable if its owner can show that the mark has acquired distinctiveness in the mind of the relevant consumer. This means that although the mark clearly describes something about the applicable goods or services, the purchasing consumer immediately thinks of that particular source when it encounters that mark. In the band name context, an exaggerated example of a descriptive mark that could be a group that calls itself "We Play Rock Music." Unless the mark's owner could demonstrate that music consumers associate that highly descriptive mark with that particular group, it would not be very protectable, and also should not be entitled to federal registration. Moving up the strength scale, next are suggestive marks. These are marks that suggest some quality, ingredient, or characteristic of the goods or services that they represent, rather than actually describing them, as was the case with descriptive marks. Again, in the band name context, a group that called itself Soulful Groove would likely be considered a suggestive mark for a band or musical group. Next on the strength scale are arbitrary marks. Arbitrary marks are comprised of common words and or other elements used in a way that does not naturally suggest or describe an ingredient, quality, or characteristic of those associated goods or services. For example, going back to Apple, for computers, again, Apple would be considered generic if it were used to identify apples. But the word Apple and the famous Apple logo have absolutely nothing to do with computers or electronics, absent the distinctiveness that Apple has developed in the minds of consumers. The Beatles, the Cars, Journey, and one of my personal favorites, the fabulous Superlatives, Marty Stewart's band, are all examples of arbitrary band names. In each case, these words have common meanings, but they're not naturally associated with music. Finally, fanciful marks are coined marks that are invented or selected for the sole purpose of functioning as a mark for particular goods and services. In other words, these are words and or designs that just did not exist before their owners created them. Probably the best example of a fanciful band or artist mark was the graphic mark associated with the artist formerly known as Prince in the 1990s. As illustrated on our scale, arbitrary and fanciful marks are the strongest, most protectable marks, and what most trademark lawyers encourage their clients to aim for. A mark's distinctiveness is one of the issues examined during the federal registration process. But as we're going to discuss in the next part of this series, one acquires rights in the mark through actual use of that mark in commerce rather than through registration. So the protectability and strength issues are relevant even if one never plans to register a mark with the U.S. Patent and Trademark Office. When considering band or stage names, it's a great idea to come up with several alternatives. When conducting trademark clearances, trademark lawyers will start with the most preferred name, and if that one is not available or perhaps not very protectable, he or she can then move on to the next mark in order of preference. It's also a great idea to try to narrow your list down by conducting your own internet searches before submitting your final list to your trademark lawyer. These two steps can save you both time and money. DeSalvo and Levine has created a complimentary trademark services guide that contains additional general information about trademarks and service marks, including the steps involved in clearing and registering marks, as well as pricing for a number of frequently requested services. Our trademark services guide is available on our website or via the link above.